All right. Court of Appeal and then for the state of is now in session. The Honorable Mary Nardella, Judge, signing. All persons having been to the court, solemnly here give attention to you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning.
Morning.
Welcome to an oral argument session of the 6th District Court of Appeal. I am Judge Nardella. Joining me today on the panel is Judge Brownlee and Judge White. We have 3 cases for consideration today. The first is Law Minnesota Riviera LLC versus Riviera Golf Estates Homeowners Association, Inc., 25-0443. Counsel, as you are aware, every party gets 20 minutes per side. As a privilege to the appellant, you also have a rebuttal if you choose. We typically set aside 5 minutes for rebuttal, although if you'd like a different increment of time, let me know. Is 5 minutes acceptable? Counsel, whenever you're ready.
Thank you.
May it please the court. My name is Alex Figueres, and I represent the appellant, Law Minnesota Riviera LLC. We are here today because the trial court committed reversible error when it misapplied the exception to marketability found in Florida's Marketable Record Title Act. I think our beginning point needs to be the purpose of the statute. Section 712.10 tells us that this law shall be liberally applied, shall be liberally construed to effect the legislative purpose of simplifying and facilitating land title transactions. So that is the policy. By allowing persons to rely on a record title, as described in section 712.02, subject only to such limitations as appear in 712.03. And that's what we are going to be discussing today. The trial court misapplied the exceptions found in section 712.03 subsection 1 when it looked to the affidavit of Myron Gifford for the preservation of a 50-plus-year-old deed restriction. So if the trial court couldn't look to the affidavit of Myron Gifford, where should the court have looked? Well, we have guidance. The Florida Supreme Court has given us that guidance. And in the case of H&F Land versus Panama City, that's a 1999 case, the Florida Supreme Court tells us that we need to look on the face of the deed for the preservation of the restriction. In fact, that court went through the same analysis that the trial court should have gone through. And in so doing, they held, initially, we note that the term root of title refers to the last title transaction creating the estate in question and which was recorded at least 30 years ago. I'll come back to that. That's the starting point, the root of title. In this case, the root of title is the 1947 conveyance from Bay County to the Panama City Airport Board. So they acknowledge root of title. That's where they're going to start their analysis. And it says for this exception, they're analyzing an exception under 712.031. For this exception to apply in the instant case, the 1947 deed from Bay County to the Panama City Airport Board would have had to disclose on its face the common law way of necessity. And that was the restriction that the court was dealing with to see if that had been extinguished or not. The court then went on to find that in the instant case, the 1947 transfer to Panama City, that deed, never mentioned or referenced the common law way of necessity. Therefore, it was not disclosed by the muniments of title as provided for in section 712.031.
Doesn't the affidavit in our case, though, incorporate by reference, and I'll have to pull it up to be exact, but perhaps you can help me. Doesn't the affidavit reference the 1973 deed that then does contain the page number? Like it would make that disclosure?
The affidavit does attach it, but I don't concede that it complies in any way with the exceptions under 712.031. Again, those exceptions have to be narrowly construed. We're told that it needs to be found in a muniment of title, and we have guidance from the Florida Supreme Court that tells us we look to the deed.
Counsel, it's your argument that an affidavit can never be a monument of title. Is that correct? I know you're arguing it's not in this case.
I'm not conceding that. What I'm saying is that for purposes of this particular case, we don't even need to get there. The August deed is the proper root of title. That deed never disclosed, never the deed restriction, and therefore we went on that basis alone.
Okay, so your argument about the root of title is that the word purporting must be doing some action, correct?
Correct.
Okay, is there any hypothetical, and I'll ask this of your colleague, is there any hypothetical where the word purporting does any action if we accept their construction of the word effect in the definition of title transaction?
I don't believe there is. Again, I think the statute is very clear. It has to be narrowly construed. Muniment of title is a defined term. I'll get to that. We need to start with the root of title. We look to the muniment of title to see if there's been any deed restriction preserved. If it has not, it doesn't. In this particular case, we don't even get to the affidavit, but even if we did. So my first argument, which I'm not abandoning, is that the August deed is the root of title, and we need to look no further.
So a root of title under your argument can be defective.
I believe that the law says that it may be defective. Correct.
Does it matter
Correct.
what kind of defect it has? Does it matter
I
the
don't-
latent defect?
I don't think it matters. I think there's actually precedent that says even a forged deed can serve as the root of title. So
Does that make sense in the scheme of the statute for it to operate correctly for title transaction?
Again, I believe it does, because we look at the word. First, we need to look at the document. So that's the first thing. We're looking at the affidavit. Does it purport to transfer title?
But is the August deed purporting to transfer, or is the July deed purporting to transfer? Set aside the argument about the affidavit, and then that August deed is just correcting something that already purported to transfer. It almost seems like the August one is for notification, for recordation.
Unequivocally, it purports. When we look at the face of the deed itself, we have a grantor, we have a grantee, we have a description. In fact, that is the deed that would show up in the chain of title.
So in determining whether or not it purports to make a transfer, is it good enough to look at that and that alone, that one document, this deed, we don't look at what came before it, whether or not it did something. We only look at that deed. Does this deed look like it does something?
Yes, and that's exactly, again, it's the same analysis that we do for muniment of title under 712.031, and the same analysis that the Florida Supreme Court directs us to do when trying to see if a restriction of any type was preserved. We need look no further than the face of the deed. And that's exactly the argument that I'm making, that in that August deed, we need to look no further. We only look to that deed. That deed does not preserve in any way the restriction. But even if my fallback argument is just as strong, even if the July deed somehow was the root of title, when we look at that document standing alone, it also does not preserve the deed. It doesn't reference it. Moreover, it doesn't mention or incorporate by reference the affidavit whatsoever. In fact, the affidavit is a document that was recorded prior in time to the July deed. And that's important because
How much prior? I know it's the same day. Does the record disclose that the word in sequence is used in the brief?
it does. And in fact, the documents are actually in the record at 1272 through 1282. That shows the actual sequence. And that's exactly what I argued to the trial court. In fact, the sequence, and it's kind of counterintuitive because for purposes of an analysis, we have to go back in time. So we have the July deed. Prior to that, we have a satisfaction of mortgage. Prior to that, we have the affidavit of Gary Wilson. And then we have the affidavit of Myron Gifford. So even under the definition of root of title, again, if we look at the definition, let's do that. Let's look at the definition of root of title. 712.01 subsection C6, I'm sorry. Root of title means any title transaction purporting, which is what we were talking about, to create or transfer the estate claimed by any person, which is the last title transaction to have been recorded at least 30 years before the time when marketability is being determined. So for our purposes, I think a timeline would be instructive. We're determining marketability as of August 8th, 2022. That's when the association filed their complaint. So that's our starting point to determine marketability. What the definition of root of title tells us is we need to look back from that time 30 years. If we look back 30 years, it takes us to August 8th of 1992. Then we need to look at the next document in sequence there, the next title transaction. And what we have here, in fact, what was before the trial court is the next one, is the August 1st, 1990 deed, which is the root of title. Next in time, we would have the July deed, which was recorded on July 17th. And then last in time, we have the Gifford affidavit, which, yes, it was recorded the same day as the July deed, but from a MARTA perspective, timing is key. Here, again, the definition says the last title transaction as between the July deed and the Gifford affidavit. The July deed is the last title transaction closest to when we're making to 30 years before we're making that determination of title. So even there, we prevail, right? There's another argument yet, and that is that the Gifford affidavit is not a muniment of title. Unfortunately for us, the statute doesn't really define muniment of title. So we have to go to the case law. And there is the case of Matisek versus Waller. And that's a Florida 2nd District Court of Appeal case from 2011. And that court defines muniment of title as any documentary evidence upon which title is based. Muniments of title are deeds, wills, and court judgments through which a particular land title passes and upon which its validity depends. Muniments of
Counsel,
title.
has the Florida Supreme Court defined muniment of title?
It has. The Florida Supreme Court has actually adopted a Black's Law Dictionary definition, which is very similar. Basically, what that definition tells us is, let me back up. Black's Law Dictionary defines muniment of title as documentary evidence of title as a deed or a judgment regarding the ownership of property. So it's not as expansive, but the Matisek.
What case or cases
Is
are
it
you relying?
sunshine?
I'm sorry, what was the question?
What case or cases from the Florida Supreme Court are you relying on for the definition of municipal title?
Well, for purposes, I'm relying on the definition from the Second District Court of Appeal, but there are a couple of Florida Supreme Court cases that did define muniment, or that used the Black's Law Dictionary definition that I just read right now. As I sit here today, I'm not able to point to a specific Florida Supreme Court case, but yes, the definition that I read from Black's Law Dictionary has been adopted or has been used by the Florida Supreme Court in at least one case that I'm aware of. So
Counsel, can I get you back? I know you're in your affidavit argument, but I'd like to loop back to the August portion. And I understand your argument to be that you don't need that, right? Even if you let that argument go, your fallback is that you went on your second argument regarding whether the affidavit is a valid muniment of title. But taking you back to the August 1990 deed, can you explain to me what's your best argument for why that deed would affect, like, why would it be a title transaction? Meaning, does it affect title to any real estate? Like,
it definitely affects. I mean, the parties certainly thought it affected it. Otherwise, they wouldn't have recorded it. And again, even a corrective deed affects title. It's part of that chain of title. Just being part of that chain of title definitely affects title. It definitely supports.
but it's not transferring title, it's not creating title, it's just sort of recognizing that title previously transferred, right?
I disagree with that. I actually do think it transfers title, and I think the parties thought so as well. They thought the defect in the July deed, at least.
Oh, had not
Yeah,
validly
they-
transferred?
Correct. They thought that they needed to file this in order to transfer, but even if
Is
it,
that in the record? We have that? Like, do I know that in my role?
what was the question again? I'm sorry.
Sorry, you're saying they thought they needed to do it because their understanding, their subjective, I would think, understanding is that they did not previously transfer title by way of the July, not in the record?
That's not in the record.
Okay.
It's just in the transaction itself. Obviously, the fact that they felt the need to do that, there was an issue with the notary block where the grantor had not been
Right.
identified.
Does it matter under ITT Rainier Incorporated? Under the Florida Supreme Court's analysis in that case, where they found that a void instrument, which clouded title, affected it under title transaction? Wouldn't it be the opposite also be true?
Correct. I fully agree with that. There is no way that corrective deed does not affect. It certainly does. I agree with that. And again, August 1990 deed is the root of title. My fallback argument, even if somehow that's not deemed we look to that July deed. Again, we're looking to the face of the document under 712.031. We have to look at the muniment of title itself. Does it preserve it on its face? It does not. I see that I'm running out of time, so I will reserve my time for rebuttal. Thank you, Your Honors.
May it please the court. Garrett Tozier, along with Michael Witt from Schutz and Bowen on behalf of the Appalachia Riviera Gulf Estates Homeowners Association. This court should affirm the final judgment declaring that the restriction on the golf course is not extinguished under the Marketable Record Title Act, Chapter 712 MARTA, until August 18th, 2030, because that is the date that it will be 30 years past the 2000 title transaction.
Counsel,
But-
can we
yes.
begin your analysis with the root of title decision there? Obviously you guys part ways. Can you explain to us what work the word purporting is doing in the definition of root of title?
The word purporting would mean suggesting to do the action that follows it. It is suggesting that it is taking the next act, the verb that follows it.
In this case, the word purporting does not. Is that correct?
It depends on what you're applying it to, I guess.
Yeah, can you give me a scenario where I would use the word purport, where the word purporting
Mhm.
in the definition of root of title would be doing work?
The word purporting, I believe there were forged deeds was referenced earlier. I think wild deeds can still,
Yeah, let's talk about wild deeds.
okay.
Where would the word, how would the word purporting be doing work in a wild deed scenario?
It would purport to transfer it from the grantor to the grantee despite not being within the chain of title, I believe would be a suggestion. I think there is,
But that could still be the root of title.
it could be, and there is case law holding, I forget what case it is specifically, but the wild deed could be a root.
Why doesn't that logic go in favor of opposing counsel?
Because for a couple of reasons, it has to be a title transaction that purports to create or transfer the estate, I believe is a correct language. And first of all, that is not a title transaction that happened on August. They were relying on August, right? The August re-recording deed, because title had already been transferred, the property had already been conveyed. All it purports to do is to correct information that actually did not affect title. The July deed.
How do you know that? Do you only know that from the history? If I'm in the business of making sure I'm going to give insurance for this title transaction, correct?
Correct.
And I look at this one deed.
Mhm.
It purports, does it not, to transfer? If I'm looking at it without a history, without context, not taking everybody's deposition, I'm just looking at the document itself,
You're referencing the August recording, the re-recording, or the
Correct.
July?
the corrected deed.
It, first of all, it retains the original book and record page numbers, the 1544 from July 17th. And then it just adds the additional information here. This is all it purports to do, is to add information in the notary block, which you were asking for record support or prior discussion of this. The argument in the trial court regarding the August deed is actually not the same one as they raised here on appeal. It was that the July deed was actually defective and it did not actually transfer title. And therefore, that's why the
I think
August.
It's important. I assume that was settled between both sides. And it sounds like you're telling me it is not.
So that was their argument on page 940 to 941 of the record. They cited in the initial brief. They didn't explain why they told the court you don't need to look at the July deed in the initial brief. But if you look at the actual argument,
Is
there
the
was
July deed void?
no,
Okay.
no,
So the July deed gave something.
yes,
So your argument is the August deed can't give it.
correct,
And therefore doesn't affect title.
correct.
Correct. But the definition of root of title says purports. What do we do? I'm still confused on
Sure.
how that word has any operation.
I'd like to help you out there.
Yeah.
If I could. It means any title transaction purporting to create or transfer. So you have to look at title transfer first in subsection 7. A specific definition that isn't, by the way, not once mentioned in the initial brief. Title transaction means any recorded instrument or court proceeding that affects title. So you don't hit title transaction first, which is incorporated into the definition of root of title, then you don't get to the title transaction purporting to create or transfer the estate.
What do I do with ITT Rainier when it gives me a broader view of the word effect? I mean, it says the word
Sure.
affecting. Okay.
Yes, it says affecting is to produce an effect upon. I believe that would be consistent with what Black's Law Dictionary would currently define that. The
Which
word,
for them includes unclouding title.
but this doesn't affect the title. And I can explain why, because our counter argument in the trial court at record pages 1242 through 1244 was that missing notary block did not render it defective. So all that this August deed purports to do is to add information that does not affect the actual recording or the conveyance of the
Is
deed.
that obvious? You gave it to me before and I don't quite understand it. If I'm just looking at the corrective deed,
Mhm.
how is it obvious to me without history that the only thing it's doing is correcting the last deed? It's not actually making a transfer.
Because you have the 1544 book, original July, and the record page number of
So it's going
2181.
back to the book, which
It-
makes it obvious. It's not on its face obvious.
Yeah, it's saying on its face, all I'm doing is adding information in the notary block, which we explained in the trial court, is not necessary to validate the deed, not necessary to convey the property. And so there was nothing, and then again, also, I guess our other point at the trial court was that there was nothing else to convey on August 1st. Title had already been transferred. It had already been accepted by the grantee 2 weeks later when this was re-recorded. So there was not a second title transfer that occurred. It's not like they voided the deed, undid everything. They took the original, signed May 1st, 1990, didn't have the notary re-notarize it, and then added information and altered the block that's underneath there. And all it says on its face is, we're just adding this additional information, which doesn't
It
affect.
says that.
What's the
Quote,
record site
end quote.
for it?
Oh, yeah, sure. Sorry. It's 767 through 767. It's exhibit 7 to our motion for summary judgment. This document is being re-reported to correctly reflect the grantor in the notary. Remember before it was blank. The blank version can be found at record page 12 or 55 through 56. And then the only difference when you go back to 767 is the name of Mr. Gifford in the notary block that concludes if it was blank. To me, well known to be the person described as grantor. And Mr. Gifford is the only person signing on behalf of Riviera Golf Club Co., the grantor, as the general partner. So it doesn't actually add any missing information. That's why it wasn't invalid. And we explained that in the trial court, and it wasn't raised on appeal, along with the argument that I heard earlier about whether the July or August the statute under 712.03 subsection 1, the clause that starts with provided that, and you have one of two options in which you can use to.
Counsel, I'm
Yes.
sorry, let's go back for a moment.
Sure.
Which, are you making an argument that appellant has failed to preserve an argument below?
Oh, thank you. I did not finish that thought. The actual argument that they raise on appeal is different than the one that they raised in the trial court. They're saying on appeal, not that it was void and therefore for the first time, August 1st was the first effective deed that transfer title, which was wrong as a matter of law. It assumes that there were two title transactions that occurred. One that happened in July and then another one that happened 2 weeks later. That's not the argument they raised in the trial court. And that's what's in the initial brief though. So it's a different argument. And that's why it doesn't affect title, because we now assume, based on the arguments in the initial brief, that the July title transfer was valid, right? Is that?
That only, so that lack of preservation, as you put it, and I'm sure council will address it, but if that was not preserved, then we would still have to address the fallback argument regarding the July deed.
Yeah,
And
the
the affidavit.
And the affidavit, absolutely. And I'd be happy to go there next if that answered your question.
That does answer the president. So let me ask a follow-up
Sure.
question. With respect to, if we disagree, or maybe I'm misunderstanding your argument, but if we find that we can rule on whether the August deed is the root of title,
Mhm.
I'm having trouble, and my understanding of your argument is it's not. Is that correct?
Correct.
Okay. So I'm struggling,
Mhm.
counsel, with reconciling your argument with the ITT Rainier case, being Wadsworth,
Yeah.
Florida Supreme Court, where they specifically adopt the definition of purport in the Webster's dictionary. That's in the opinion. It
Mhm.
says that means to profess outwardly, have the often specious appearance of being. Certainly, the legislature intended the word purport to have its accepted meaning. The 1937 deed meets that meaning, even though they then later say the 1937 deed, whether partially ineffectual or not, quote, affected title and was a title transaction as those terms are construed in Marshall.
Marshall.
How can make your argument of how I would not be violating the Supreme Court's decision here if I reject appellant's argument that the corrected deed is not the root of title and is not a title transaction?
So the ITT case was first cited in the reply brief and there was no discussion. I will get to the substantive answer, but I just wanted to point out that was cited and raised for the first time in the reply brief. I would think any arguments saying that something is or isn't a title transaction would have been waived because you have to get title transaction before you get to the root of title, before you get to the word purport. And there's no discussion of that in the initial brief, but to substantively address what purporting means in that context from the ITT case, which I believe cited you said the Marshall Court DCA decision that stopped it by the Supreme Court. it's purporting to create or transfer title, but that modifies title transaction. And so that's why I think that affecting, you have to actually produce some sort of substantive effect on it. And that's because you have to get from 7, you have to pull the definition of title transaction from 7 to bring it up to subsection 6, right? Into the definition of root of title. And so if it's not a title transaction, then the words that follow purport to create or modify, first of all, are rendered ineffective, and it wouldn't apply in that scenario. If that makes sense? Because
Counsel, in addition to the definition of purport, it also provides a definition of a fact. It says even a void instrument of record affects land title by casting a cloud or a doubt thereupon.
and when you're taking the statutory text and applying it to the facts of this case, it doesn't actually affect or cloud title in any way, because
It does the opposite. The corrective deed, correct?
It's clarifying the title.
but the title has already passed and transferred. There's nothing substantive there that's missing for it to be ineffective. And that goes back to the point that I made earlier, that their point in the trial court was that it was defective or ineffective. And that's not, they haven't substantively argued that on an appeal. And we explained why it was effective in the first place. And so I don't see the substantive change between the two versions here. It adds additional information, but doesn't affect title.
Counsel, can you explain again,
Sure.
because I'm not following?
Sure.
When would the first word purport have meaning in this statute?
When would it have meaning?
Yeah, give me an example. When the word purport for root of title would have some meaning, would make some difference. It would explain to me why the legislature put that word in there to begin with.
Well, I believe the ITT case held it, or was citing a case that held about the wild deed scenario. But when that wild deed scenario comes up, they don't have title in the first, or purported title from the wild deed in the first place. This is a title transaction that has already occurred 2 weeks prior, and there's nothing there substantively. That was the first, from my review of the cases that have been cited, the example that I had seen.
Isn't it purporting to do it in this case? I mean, if you don't know anything about the July deed, if you're searching title and doing your due diligence, and then you just come to August and you don't know anything else, isn't the August deed, set aside whether it's a title transaction, I understand your argument on that point, isn't it at least purporting to affect title in this case? Because it's not really doing it, right? That's your argument.
Right.
July did it, August didn't do it, but nonetheless, it's sitting there, isn't it purporting to? I feel like it's doing work in this case.
You would have to ignore the July 17th date that's on the face of that same document, that exact same page of the record, that has the 1544. And so you would have to read it in context of that specific book and record page. Like I said,
I see.
if you ignore, this isn't a scenario where they canceled the deed, transferred it back, and then they got a corrected information and had a separate title transaction. And so when they just use the exact same information, that alerts everyone to
It's because it says this document is being recorded to correctly reflect the grantor in the notary. Is that, and the reference to the book and page number?
it's not an incorrect statement from the prior one. It is blank. It's blank in the original.
Right.
It doesn't have any information there.
I was reading from the August.
Right, exactly. So, but you have to read that in context with it, right? You have to understand, like, all right, what is it correcting? Let's look at the 1544 one that was originally reported. That's the book number, page 2181 of the official records. So that's why you have to read it all in context and realize that nothing substantively as a matter of law has changed, because it was valid when all this happened back in July. In terms of the muniment of title argument, I believe the dictionary definition that was read was the 9th Black's Law Dictionary 9th edition from H&F. That was case. It has a very similar definition to what the prior versions of Black's Law Dictionary had used. The Sunshine Vistas case that I believe was referenced earlier, that has a definition for documentary evidence of title, the instruments of writing and written evidences which owners of lands, possessions, or inheritances has, by which one is entitled to defend the land. So this is turning back to whether the affidavit is immune to the title. And if you examine the content of it, yes, it has information that that the grantee could use to help defend the title, that he received it from they received it from someone who owned it, from a partnership that was authorized to do business in Ohio law, authorized to do business in Florida, and that he was authorized to act on behalf of that corporation to transfer that deed that is attached to it and identified by book and record page number. So
But doesn't the muniment have to be transferring the title? Doesn't it have to, it does more than affect title, right? Is it documents like deeds, wills, court judgments through which a particular land title passes? Or do you dispute that?
I would respectfully suggest that it is not persuasive authority of the two decisions that they cited, the Matisic second DCA decision, which I believe is where they engraft additional limiting language on the definition of muniment of title, that it must pass, it must carry title. There's no cited authority in Matisic besides the second DCA's Cunningham decision, or the fifth DCA, excuse me, Cunningham decision, which cites zero authority for its definition that is narrower than the Black's Law Dictionary version that says documentary evidence of title on which one can use to defend their title. So I think, and since the Florida Supreme Court has adopted Black's Law Dictionary, the broader definition, I think this court should not rely on those unpersuasive decisions that cite no authority, and instead just follow first principles and read the relevant statutory text in its context, apply it to the facts of this affidavit here that meets that Black's Law Dictionary definition, as I described earlier.
And I'm sorry, which edition and which Florida Supreme Court case?
That is the Sunshine Vistas 1993 Florida Supreme Court decision that cites the 6th edition of the Black's Law Dictionary from 1990. And I would go back in time and go further back if there were cases.
What about the Clipper Bay decision in 2015?
Right, that cites the 9th edition of Black's Law Dictionary, the 2009 version, which it still says documentary evidence of title, but it says such as, and those are examples. I don't think that's a limiting.
But isn't an affidavit different in kind than those examples that are listed?
It's still a document. It's different in kind, but I don't think that, I don't think that.
I mean, it's not akin to a deed, right?
But it's still a documentary evidence. And I think that's all it's doing in terms of giving an example for why that it could be evidence that would be in the chain of title. And importantly here, it is consecutively, these 11 pages consecutively recorded all in sequence. That's the trial court at 1361, paragraph 4 of the record. Paragraph 4 of the order found that those 11 were the title transaction, those 11 documents, including the affidavit, including the July original deed. And it is, and so it's our position that you should accept this general broad definition of muniment of title. That is the issue that we believe is preserved in the trial court, and I argue with adequate specificity here.
Do you think that it matters which version of Black's we use to define muniments of title?
I think generally the better approach is to go farther back in time, around the time that the Florida legislature passed it. That's better evidence, I think, of
Is that the 6th?
Well, you'd probably have to go back even farther, but that's the first Florida Supreme Court case that I know had cited that, and that was the only one cited in the briefs. So what, the 5th edition, whichever version, but that's the first one that I know the Florida Supreme Court adopted. So we respectfully request that you agree with our broader definition, and unless this court has any other questions, we respectfully request the court affirm the final declaratory judgment.
Your Honors, if I may, the first issue that I want to address is in the record at page 940, where it talks about the corrective deed. In there, in the briefing, in my amended motion for summary judgment, it clearly indicated that Riviera argues that corrected 1990 deed in August deed is the proper root of title, and the court need not look at or consider the 1990 warranty deed. Again, we need to look to.
Sorry, counsel, what was that record citation?
940.
940?
940.
All right, thank you.
Correct. And again, we need to look at the policy that that the legislature is trying to apply in this particular case. It's trying to simplify and facilitate land title transactions. The court's final judgment has the opposite.
Counsel, let me
effect.
ask you, if the affidavit that opposing counsel relying on was specifically referenced and attached to the August 1990 deed, would your client lose?
That's not what happened here, so I don't
I
know.
know, that's a hypothetical.
More than likely, yes. I think if it had been referenced, although I don't concede that fact. Again, I don't think that's not what we're dealing with here. When we look at the face of the deed itself, we don't find that. The only place where we find the deed restriction is in the affidavit. We don't find it in the July deed, and we don't find it in the August deed. And again, going back to the Florida Supreme Court case that went through that same analysis, I want to point that out because I do think it's important. They already told us where to look. They went through that same analysis, and they said in the instant case, when they looked at that particular deed, the transfer to Panama City never mentioned or referenced the common law way of necessity. Therefore, it was not disclosed by the muniment of title as provided in section 712.031. My main argument and my strongest argument is that the 1990 August deed is the root of title. We need to look no further than that. It absolutely purports to affect title. There's nothing in there that preserves the restriction. My fallback argument is even if we look at the July,
Counsel, what do you say to their argument that it doesn't purport to do it because it purports to do the opposite?
that is correct.
It purports to do the opposite, which is to tell you, this is just a correction. We're not doing
It-
anything here, but filling in a blank space on a notary acknowledgement.
No, for purposes of the definition of root of title, it actually does. If we look at the definition itself, that really is what it purports to transfer. There's no
But it has
question.
to, before it meets the definition of root of title, it has to meet the definition of title transaction, right? In order to even get embedded within the root of title definition.
Right, and there's no question it's a recorded instrument that affects title. There's no question.
But I think that's what she's asking, right?
Yeah.
So they're saying it doesn't affect title. It's not even a cloud on title. It would be the opposite of the cloud on title. It's clarifying. There is no cloud. There is no problem.
And a clarification affects title. That is the whole purpose of a clarification.
Counsel,
It's
is
correct.
your argument that it doesn't have to be a cloud on title, a perfectly legitimate, undisputed deed affects title, doesn't it?
Right, that's exactly my argument. In fact, from a root of title analysis, what we're looking at, it's a timing issue. We're looking to that last title transaction. And obviously in this particular case, it does purport. And
But is it
therefore-
purporting to do that? I mean, if you look, they have brought to our attention the face of the document itself, the face of the August 1990 deed, where it notes what it is purporting to do, right? It's correcting the problem with the notary stamp on the July deed. What's your response to that?
Well, the fact that it's recorded subsequent to, it's part of that chain of title. It purports that correction affects title. There's no.
Does
question.
every recorded deed affect title?
It can, I think it really depends.
Under
Again,
ITT's definition, does every recorded deed affect title?
I don't think so.
Okay.
So again, Your Honor, in closing, one of the things that I would respectfully request is a written opinion on this issue. I think there's a lot of lack of clarity on what a muniment of title is and whether an affidavit even qualifies for that. Again, from a public policy perspective, the idea is to simplify and facilitate, and based on the fact that the affidavit on its face is not a muniment of title, it's not referenced or incorporated by reference into that July deed, it's a standalone document, not a muniment of title. When we look at the face of the deeds themselves, we don't find any preservation of that restriction. And therefore, there's no set of circumstances where the restriction remains until 2030, and the trial court must be reversed on that basis. Thank you, Your Honor.
Thank you both. Well argued and well
Yes.
briefed. We appreciate it.
Thank you.